All right, some developing news right now out of California, where the Winslow jury continues to deliberate. As I told you just before the break, we did get word that the defense filed a motion to dismiss several of the remaining counts in this case. Counts related to Jane Doe number 1, who accused Winslow of rape, and Jane Doe number 4, who is the woman who claimed she was raped when she was 17 back in 2003, among with several misdemeanor charges related to those. Let me just read a little bit from the motion that was filed. The attorneys write that the jury was let me go back to the part. The jury entered a verdict on 4 of the 12 pending charges against Mr. Winslow without first inquiring whether the jury was hopelessly deadlocked as to the remaining 8 counts. The court proceeded to read and accept the jury's verdict as to the 4 counts in question. 3 of the 4 counts related to misdemeanor conduct with no special allegations attached. 2 misdemeanors resulted in a guilty verdict, while the jury acquitted Mr. Winslow of a 3rd. Also among them was count 4, the forcible rape of Jane Doe number 2, for which the jury returned a verdict of guilty. They go on to say that basically in this case it's clear that the jurors must find reasonable doubt if after 4 days they can't agree on the other counts. What do we make of this motion, Catherine?
I think it's a Hail Mary. Obviously the jury is entitled to deliberate for as long as reasonable. If, you know, they said that they were deadlocked and an Allen charge was given. An Allen charge is where the judge basically says, firmly handed, listen, guys, you got to go back there and you got to do this. And the jury, from my understanding, expressed their willingness to do so. They didn't come back and say, Judge, there's no way we can do this. They went back in there, decided to hash this out. So I think it's too early and too soon for this type of motion.
And let's point out, they went back in and then he sent them home at 4:30. I mean, they announced their verdict around 3 p.m. California time. They went back in only till 4:30, and I think they've only been back for maybe a maximum of an hour and a half this morning. So there hasn't been too much additional deliberation since they announced they were deadlocked. The motion goes on to say, in a case where the jury was only able to come to an agreement on a 1/3 of the charges presented, it made the resounding, unequivocal, and unanimous determination that the people had not proven beyond a reasonable doubt that Mr. Winslow committed any offenses enumerated in section 667.61 against any other victims. That's not necessarily true.
No, I mean, absolutely not. I mean, you can take sort of the low-hanging fruit. The jury can say, listen, these are these ones that we've easily been all able to reach a consensus on. But here are these other ones that we really need to hash out, and they're entitled to do that. I mean, listen, this is not a case where there's one complaining victim. There's a lot of victims, there's a lot of charges. They need time to sort this out and to deal with any type of interpersonal issues on the jury that we've already said seem signaled that they're having. So I think that this is all kind of par for the course, and defense are just throwing up a Hail Mary to get this thing tossed.
Yeah, I mean, it does seem that way. Is it unusual that the court would, bring the attorneys back in to discuss this as opposed to just denying the motion from Chambers?
I think that the judge always needs to be careful to entertain anything that is brought before the court, such that if they improperly deal with it, it can be more of a basis for an appeal, especially when there's someone who has such resources, high profile, money. The court wants to entertain everything in the proper way, so it can't be overturned later.
Yeah, that's what we're waiting for. I'm just keeping an eye on our monitor out of the courtroom in California, because we are expecting both sides to enter in just a few minutes and to hear what the judge has to say about this motion. In the meantime, let's go back to the defense's closing. What were their arguments about why their client was allegedly innocent on some of these charges? Let's go back and listen. Meantime, we're learning that the Winslow jurors have just sent a 6th note out. We are standing by to find out what the contents of that note is, and we now have a live picture for you out of the courtroom where you can see Winslow's attorneys are back in the courtroom waiting for the judge to come in and presumably rule on the motion that they filed to dismiss some of the remaining counts here. Now, we were just listening to their closing arguments. We know, obviously, the analogy the attorney gave, look, this is a boat with holes in it and it's sinking. The reasonable doubt is sinking this boat, the water's getting in. And we heard him talk through some of their arguments, some of the reasonable doubt that they tried to paint, right? I mean, we know it didn't work with Jane Doe number 3 when he said she couldn't recognize his tattoo because the jurors found Winslow guilty on that count. But he goes back to talking about Jane Doe 1. I mean, her daughter creating this GoFundMe page to pay for her expenses. Doesn't this look suspicious? And saying, she claims she was strangled, but there were no marks. These are counts that the jury is still deliberating on. So perhaps they were successful in painting some reasonable doubt there.
Yeah, not surprisingly, the strength, I think, of the prosecution is all of these discrete different women have very similar accounts. All of these women didn't know each other. So it's not surprising to me that the defense took the exact opposite tactics, saying you have to focus on each individual person's story without looking at the others to decide. Because really where the weakness lies is, of course, in individual credibility and individual discrepancies and the individual lack of evidence vis-a-vis the hot tub incident, right?
Right.
So we see these little holes that they're poking, and it's hard to get in the mind of the jury. We don't know if that's what they're clinging to or if there is some friction in the jury room with respect to any one of these individual issues. And you see what also the defense counsel tried to do is he tried to ward away from a compromise verdict, meaning he doesn't want the jury going back there and saying, well, we can't decide on this one, but we do all believe in this one, so we're going to vote not guilty here and vote guilty here just as a way to get a verdict in, even though we all don't really fully agree. They're trying to ward against that by focusing the jury specifically into each individual case.
Which really is what the jury should be doing. I mean, is not seeing this as a pattern, but looking at the specific accounts, the specific details, and so on and so forth. And that is what they're doing, as we see the way the verdicts have come back so far, sort of odds and ends here and there. And now we are waiting to see what the defense attorneys will say as they ask the judge to dismiss the remaining counts, or some of the remaining counts 1 to 3, which relate to Jane Doe number 1, her rape allegations, counts 7 and 8, which relate to the rape allegations made by Jane Doe number 4, the woman who alleges a rape back in 2003 when she and Winslow were both teenagers. We're going to take a quick break. When we come back, we will bring you live into this courtroom. Stay with us. All right, so the judge obviously has a lot of questions about the defense attorney's argument here. So do we. He's talking about this multiple victims allegation, saying that therefore the judge must dismiss these other counts. Can we make anything of this yet, Katherine?
I'm not buying it, and you can see the incredulity of the judge too. He's like, what are you talking about? If you look at the body of 1161, it doesn't say that.
Right.
Citing one errant case for the inverse proposition, right? I don't think it's going to stick, and you can just sense that from the judge already.
Meanwhile, though, I mean, what the defense does have on their side is the jurors saying that they're still deadlocked.
They sure do. But, the prosecution can always file charges again.
Yep. And we know the jury's going to come back in and they will be questioned about their note saying they're deadlocked. Katherine, thank you as always for being on with us this afternoon. It's great to have your insight. We do appreciate it. Stick around. We're going to take a quick break. When we come back, we will bring you back live into this courtroom in California. Plus, we'll have news from all the other big trials making news today. Stay with us.